Yes, counsel wanted to talk to me.
Yes, about the last paragraph on 28.
Yes, that was provoked by your statement in closing.
Which this changes the whole theory on which the Commonwealth has prosecuted this case. The Commonwealth has prosecuted the case from the very beginning, saying Michael McCarthy and Michael McCarthy alone killed Bella Bond. The only relationship of Rochelle Bond was that she was charged as being an accessory after the fact. So the Commonwealth's whole theory is that Michael McCarthy and Michael McCarthy alone did it. Now, to instruct the jury at this stage that they can find him guilty on a completely other theory by saying, if you believe that Rochelle Bond aided and assisted him in killing Bella, that adds a completely new theory to the case. Now, for one thing, the jury doesn't know what aided and assisted means. Mr. Deacon says if it was a joint venture, then you can find him guilty. But the jury hasn't been instructed as to joint venture. And when you say, if you believe that Rochelle Bond aided and assisted him, there have been no instructions on joint venture. There have been no instructions on aided and assisted. Being an accessory after the fact is not aiding and assisting in the murder. So, number one, if you're going to put this in, the jury has to be instructed on joint venture. Because otherwise...
So I thought that your statement, that which you started with, frankly, that you can find him guilty only if you conclude that Mr. McCarthy and Mr. McCarthy alone
right. And is
killed
there
Bella.
Is that not the theory that the Commonwealth has prosecuted
I
this
don't
matter
think
on?
that's correct as a matter of law.
Well, if he had been charged as a joint venturer, then it wouldn't be correct. But he has not been charged as a joint venturer. He's been charged only with murder, and nobody else has been charged with murder, and there has been no position taken at any point in this case that there's a joint venture. So for you to inject at in the final charge that they can find him guilty on a completely uncharged and unproposed theory of the case without even instructing them on what a joint venture is just
I did not think I had inserted joint venture into the case.
Well,
I thought I was correcting a misstatement of the law.
Well, tell me who else is charged with murder in this case.
Mr.
Is
Deacon,
anybody else
okay,
in charge?
Mr. Deacon, I certainly don't want to introduce any kind of mistake into this trial, and frankly, I don't think this case is going to turn on my instructions. This case is going to turn on the credibility of the witnesses. But at any rate,
turn on that statement,
okay,
which is wrong and in conflict with the theory that the Commonwealth has prosecuted the case from the very beginning.
Okay.
And to go and change it at this stage of the game is completely unfair, completely unexpected, and it leaves the jury with being completely unable to understand what this is in the context of the case. A new theory, aided and assisted, what is that?
Okay. Thank you for that speech, Mr. Shapiro. I'd like to hear from Mr. Deacon.
Your Honor, I don't agree with all of Mr. Shapiro's analysis by any stretch. What I would suggest is there may be a middle ground instruction that doesn't raise these issues, at least not nearly as much. I think the court could say something like, as I've instructed you, the Commonwealth has the burden of proving each and every element of any offense beyond a reasonable doubt. The Commonwealth does not have to exclude the possibility that there were other individuals involved. But the Commonwealth does have the burden of proving that Mr. McCarthy committed all the elements of the offense, can prove beyond a reasonable doubt. So in other words, just saying we don't have to exclude the possibility, because what Mr. Shapiro said was the Commonwealth has the burden of proof, what Your Honor said. And I don't think that's an accurate statement of the law. We don't have to prove that no one else was involved. But I do think maybe just saying that part, that would be a good sort of way of not introducing a theory of joint venture.
Let me just ask you this, before Mr. Shapiro starts talking. Frankly, this was one sentence in his closing argument. And the whole picture of this case, while I might think it's misstating the law, I don't think that this is some kind of critical issue. So one approach to this is just ignore it and say nothing. I'm just, you raised the issue. Hold on a minute.
Sorry.
You raised the issue at sidebar, and I heard it too, and so I was willing to try to address it, and I did try to address it. Mr. Shapiro is made his argument about why this is going to constitute some kind of egregious error. I certainly don't want to do that. This case is not going to turn on these kinds of issues, so I don't want to introduce something like that.
Here's my concern, Your Honor, and I actually feel pretty strongly about this issue. I'm not sure I share Your Honor's assessment of how the case will turn. Mr. Shapiro made an eloquent and powerful closing suggesting to the jury that Rochelle Bond killed her daughter, or was responsible for it. The Commonwealth has always argued Michael McCarthy did that. I could envision, I'm not saying it'll happen, and I'm certainly not overconfident, but I could envision a jury saying, what do we do if we find that they're both involved? If our feeling is they both involved, Mr. Shapiro has told them in his closing that the Commonwealth, he's instructed them, the Commonwealth must prove that it was Mr. McCarthy and Mr. McCarthy alone. That's a misstatement of the law. The theory on which we have always tried this case is that we can prove beyond a reasonable doubt that Mr. McCarthy killed Bella Bond. We can prove beyond a reasonable doubt that Rochelle Bond was an accessory after the fact. That doesn't mean that our theory is she's no more involved than that.
Okay,
it only means that's what we can prove beyond a reasonable doubt. But if a jury concludes beyond a reasonable doubt that they're both involved, and then default to the only instruction they've been given on it, which is from Mr. Shapiro, they're going to think, do we find him guilty or not guilty in that event?
What would specifically is the language you're suggesting?
I'm suggesting that Your Honor say, as I've instructed you, the Commonwealth always bears the burden of proving beyond a reasonable doubt each and every element of any offense charged, or however Your Honor likes to phrase that. The Commonwealth does not have to exclude the possibility that one or more other individuals was involved in the murder, but the Commonwealth must prove beyond a reasonable doubt that Mr. McCarthy, that must prove each of the elements of the offense as to Mr. McCarthy beyond a reasonable doubt. And I think that's an accurate statement of the law. I tried to do some research briefly during the break. I can't find the case law, but I'm quite confident that the state of the law is that if we charge one individual, we don't have to exclude the possibility that others were involved.
So the Commonwealth does not have to exclude the possibility that one or more other persons were involved in the crime. It does have to prove beyond a reasonable doubt that Mr. McCarthy committed the crime charged.
Yes, and I think that's an accurate statement of the law and doesn't introduce any notion of joint venture.
It's not an accurate statement of the law, given the theory that the Commonwealth has gone on in this case. It is not an accurate statement at the last minute to say, oh, we've prosecuted this case on the theory that Mr. McCarthy killed Bella Bond based on the testimony of Rochelle Bond. You all heard it. He went into the room. He struck her in the stomach. Only he did that. Now, for the Commonwealth to say, well, maybe there were other people involved. Maybe Rochelle Bond was involved. Maybe Michael Sprinsky was involved. Maybe there were other people involved. That is contrary to the theory in which they prosecuted the case. And to open it up at this stage and throw that issue in is going to make a mess of the case. Now, yesterday we talked about that. And the court raised the issue of whether we should say anything about other people being involved. You raised that issue?
Frank, I don't remember thinking of it quite like you apparently thought I was thinking of it.
We both said no.
Okay.
And now to suggest that
Okay,
At this point-
I'd like to take a break and try to revise this instruction. I do think it misstates the law, Mr. Shapiro. I don't want to go overboard in trying to correct the error, but I do think Mr. Deacon has a point. I'm going to take a recess. I'll be back. Your objections are all noted. You've made the record clear, and you can object, certainly following any instruction if you continue to disagree with it.
What I don't understand is how it's an inaccurate statement of the law given the way this case has been prosecuted. It's been prosecuted with only one person charged with murder and nobody else.
Okay,
And there hasn't been a
Mr. Shapiro, you're repeating yourself. I'll be back in 2 minutes. I'll be in recess.
Court, all rise, please. Let's in a brief recess. You may be seated, thank you.
Okay, I tried to incorporate Mr. Deacon's suggestion. Mr. Deacon, do you think, before I hear from Mr. Shapiro, do you think that embodies the idea that you suggested here? Corrects in what you regard as a misstatement of the law by Mr. Shapiro, but doesn't go too far?
Yes, Your Honor.
Okay, Mr. Shapiro, without repeating your arguments.
I'm going to repeat them because this is just as wrong now as it was then.
Okay.
This case was tried on one premise. Mr. McCarthy was the one and only person charged with murder, and that was the Commonwealth's theory. That he did it, that Rochelle Bond was then controlled, made a hostage, locked up for months.
Okay, Mr. Shapiro.
Now, wait a second.
No, you've made your record.
Well, there's more
I don't need to hear it all over again.
What I want to say is this. My defense in this case is that they can have a reasonable doubt because they can consider the fact that Rochelle may have done it.
Absolutely.
Now
No.
the Commonwealth comes and say, oh yeah.
No,
Okay,
I
you
don't
can
think...
instruct the jury, and you should instruct the jury that maybe Rochelle didn't do it.
No,
And
that is
that's
not
what-
this
That's
instruction.
exactly what you're saying,
No.
because there's nobody else who might have assisted or who might have been, as you put it,
Also involved.
the possibility that one or more other persons.
We're also involved.
Yeah. What evidence is there that one or more other person was involved? So how can you put that in an instruction if there was no evidence that one or more other persons was involved?
I'm trying to state the law correctly. We'll bring down the jury. Thank you, Mr. Shapiro.
And the way you set it out at the end, you call attention to a particular part of my argument. If you, I'm beside myself.
I know you
You're just
are.
screwing up the whole case, and you're giving the jury an opportunity to do something that the Commonwealth wants you to do, and you are just buckling under and doing it.
Okay.
Without, if this is a question of joint venture, which is what Mr. Deacon said, then you put in an instruction telling what joint
So,
venture
Mr.
is.
Shapiro, I disagree entirely. Let's bring the
I'm sure
jury
you
down.
do.
I've
There's not
made your
much that you
speech.
agreed with
Let's
me
bring
on
the
this
jury
whole
down.
damn trial.
You know, I will say, by the way, Mr. Shapiro, I don't see one of those instructions I put in because, frankly, I think it's confusing, the Bowden instruction. You didn't raise it at all in your argument. I left it in.
Take it out if you want.
I kept it in. We'll bring down the jury.
This honorable court's back in session. Please be seated.
Ladies and gentlemen, now that the evidence in the case has been presented and you've heard the closing arguments of the lawyers, the time has come for me to instruct you on the law. And my instructions are going to be in three parts. First, instructions I give in every criminal case, general instructions. Second, I will instruct you regarding the law that is specific to this case. And then finally, I'll give you some brief closing instructions regarding your deliberations. I will provide you with a written set of instructions, so you don't need to worry about taking extensive notes. Just pay attention to me. I just wanted to make sure that it was all correct before I actually make copies for you. In giving you these instructions, I do remind you of my role as the judge and your role as the jury. As I explained at the outset, it's my responsibility to rule on any questions of law that come up during the trial and ultimately to instruct you on the law that applies to this case. And you must accept the law as I give it to you. You should not be concerned about the wisdom of any rule of law that I state. Whatever your private opinions are about what the law is or ought to be, it's your duty to base your verdict on the law as I define it for you. Your function as the jury is to determine the facts of the case, and you are the sole and exclusive judges of those facts. You alone determine what evidence to accept, how important any evidence is that you do accept, and what conclusions to draw from all the believable evidence. You must apply the law as I give it to you, to the facts as you determine them to be, in order to decide whether the Commonwealth has proven its case. So let me first turn to the general instructions. As I told you at the beginning, the defendant in a criminal case is presumed to be innocent. The fact that Mr. McCarthy has been charged with a crime is absolutely no evidence of his guilt. As I explained to you at the beginning of the trial, the indictment against this defendant is no more than an accusation, a procedural vehicle by which our system of justice uses to bring him before you, the jury, for trial. Mr. McCarthy has denied that he's guilty of the crime charged in this indictment, and you're not to draw any inference of guilt from the fact that he has been indicted or arrested. The law presumes the defendant to be innocent of the charge against him, and this presumption of innocence is a rule of law that compels you to find the defendant not guilty unless and until the Commonwealth produces evidence from whatever source that proves the defendant is guilty beyond a reasonable doubt. This burden of proof never shifts. The defendant is not required to call any witnesses or produce any evidence, since he is presumed to be innocent. The presumption of innocence stays with the defendant unless and until the evidence convinces you unanimously as a jury the defendant is guilty beyond a reasonable doubt. It requires you to find Mr. McCarthy not guilty unless his guilt has been proven beyond a reasonable doubt. And your verdict, whether it is guilty or not guilty, must be unanimous. I've said a couple times that the burden is on the Commonwealth to prove beyond a reasonable doubt the defendant is guilty of the charge against him. What is proof beyond a reasonable doubt? The term is often used, probably pretty well understood, but not easily defined. Proof beyond a reasonable doubt does not mean proof beyond all possible doubts, since everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proved beyond a reasonable doubt if, after you've compared and considered all the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs, based solely on the evidence that's been put before you in this case. Now, I've told you every person is presumed to be innocent until he's proven guilty, and that the burden of proof is on the prosecutor. If you evaluate all the evidence and you still have a reasonable doubt remaining, Mr. McCarthy is entitled to the benefit of that doubt and must be acquitted. It is not enough for the Commonwealth to establish a probability, even a strong one, that the defendant is more likely to be guilty than not guilty. That would not be enough. Instead, the evidence must convince you of the defendant's guilt to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. That's what we mean by proof beyond a reasonable doubt. Now, in determining whether the Commonwealth has sustained its burden of proof in this case, you must rely solely on the evidence that was admitted. What is that evidence? It falls into the following categories. First, it is the sworn testimony of the witnesses, whether given during direct or cross-examination. Second, it is exhibits that were admitted into evidence during the trial. And third is the stipulation or agreement of the parties that certain facts are true and therefore need not be independently proven. The stipulations in this case have been marked as exhibits so that you can read them, and you're to accept the facts contained in those stipulations as true. This case also included a view where we visited certain locations, and the observations that you made while on that view may be used and considered in your deliberations and reaching a verdict. Let me also tell you what's not evidence, and I've tried to do that where appropriate. The opening statements and the closing arguments of the lawyers are not evidence, nor any other arguments that you heard them make during these proceedings. Questions asked of the witnesses are not evidence. They may be considered only to the extent they give meaning or context to the answers that the witnesses gave to those questions. Some exhibits were identified for the record by a letter, but never actually admitted into evidence and given an exhibit number. And those exhibits that were marked for identification are not evidence and are not going to be sent back to you in the jury room. Anything that you may have seen or heard outside the courtroom would not be evidence. Hopefully nothing about that, or you heard nothing about this case outside the courtroom. But certainly if you did hear something, it would not be evidence and may not be considered. Objections to questions are not evidence, nor is any answer I order to be stricken from the record or told you to disregard. And if you kept notes, those notes, of course, are not evidence. They may be used simply as an aid to refresh your own memory of the evidence which was presented during the course of the trial. Some testimony or exhibits were admitted only for a limited purpose, and you may consider such evidence only for that limited purpose and not for any other purpose. In particular, you heard evidence that some witnesses in this case had one or more prior criminal convictions, and you may consider these criminal convictions solely in connection with your evaluation of that witness's credibility. That is, you may consider whether those convictions affect the witness's believability and use them as an aid to your determination of the weight you decide to give the witness's testimony. The prior convictions themselves have no relevance to the facts of the present case and are not to be considered on any other issue, that is, on any issue other than the witness's credibility. Let me speak just a moment about objections. As I told you at the beginning, it is an attorney's job to object to a question when he or she believes the question is improper or is eliciting information that should not be admitted under our rules of evidence. And certainly you shouldn't hold it against any attorney or the party that he or she represents that the attorney objected to any question or take any meaning from that. Nor should you be influenced in any way by any ruling I made on any objection or take any meaning from that. Now that we've examined what the evidence is, let me move on to how you should evaluate the evidence. You must determine what weight, that is, what importance to give the different evidence before you. The law does not give oral testimony any greater or lesser weight than documentary evidence. You may find that the credible testimony of a particular witness is very important in reaching a fact finding, or you may find that a document admitted into evidence is more important. The weight of the evidence need not depend on the sheer volume of the evidence or the number of witnesses or exhibits. You might find that a few witnesses testifying to a particular fact are more believable than a larger number testifying to the opposite. Or you may not. It's up to you, using your intelligence, your life experience, and your common sense, to evaluate the evidence. Now, just as I've told you what's not evidence, I shall also tell you how you shall not evaluate the evidence. You shall not be swayed by prejudice, bias, sympathy, or anger. You should not be influenced by any personal likes or dislikes that you come to feel toward any party or his or her attorney. You're not to allow yourselves to be influenced by the fact that the case has been the subject of media attention. You should not concern yourselves with any reaction that anyone might have to your verdict. Nor should you consider the possible consequences of the verdict, including what sentence the defendant could receive if you find him guilty. You should not consider anything I have done in ruling on motions and objections, in speaking with the lawyers, in making any gestures or facial expressions, or now in instructing you on the law, as reflecting any opinion as to how I think you should decide this case. If you believe I have expressed an opinion about the facts of this case, you must disregard it. Indeed, I have no opinion as to how this case should be decided, since that is solely and exclusively your responsibility. You must decide this case based on your evaluation of the evidence and not on speculation or conjecture. Guesswork and assumptions must play no role in your decision. Your decision must rest squarely on the evidence. Consider the evidence as a whole. Do not make up your minds about what the verdict should be until you've retired to the jury room and you and your fellow jurors have discussed all the evidence thoroughly, thoughtfully, and carefully. You may have noticed the defendant did not testify in this case. Under our Constitution, he has no obligation to testify, nor, as I told you already, need the defendant present any evidence, since the burden of proof at all times rests with the Commonwealth, the government, to prove the defendant guilty beyond a reasonable doubt. You may not attach any significance to the fact that Mr. McCarthy did not testify, nor may you draw any adverse inference from the fact that he did not take the witness stand. Indeed, you may not consider this in any way in your deliberations and are not to mention it in the course of your discussions. Keep in mind, the law never imposes upon a defendant in a criminal case the duty to call any witnesses or produce any evidence. The burden remains at all times on the Commonwealth. Now, there's two types of evidence which you may use to determine the facts of the case, and those two types are direct and circumstantial evidence. So let me define what those are. Direct evidence is given when a witness testifies directly about the fact to be proved, based on what he or she claims to have seen or heard or felt with his or her own eyes, ears, or hands. Circumstantial evidence is given when a witness offers evidence of other facts that then invite a reasonable inference about the fact to be proved. Drawing an inference is something that we do every day. We make little steps in reasoning in which we take known information, we apply our intelligence, our life experience, and our common sense to that information, and then we draw a conclusion. You may draw an inference even if it is not necessary or inescapable from circumstantial evidence, so long as it's reasonably drawn from the evidence. Let me explain with an example. Suppose the fact issue was whether the postal carrier came visit your house this morning. If your child told you that she had actually seen the mailman deliver the mail to your house, that would be direct evidence that the mailman had been to your house. In evaluating that evidence, you would need to consider whether you believe that your child was telling the truth, whether she was in a position to actually see the mailman, whether what she saw permitted her to conclude that it was truly the mailman. If your child, on the other hand, told you that she saw mail in the mailbox, that would be circumstantial evidence that the mailman had come. Nobody actually saw him come, but you can reasonably infer from the presence of mail in the mailbox, along with your past experience with the Postal Service, that somebody from the Postal Service put mail in your mailbox. In evaluating that evidence, you would need to consider whether it was a weekend or a holiday, whether you picked up the mail yesterday, whether what appears to be mail was indeed postal mail rather than something else, like a Federal Express or special delivery. The law allows both direct and circumstantial evidence. It does not prefer one over the other. Both types of evidence, if credible, can form the basis of your verdict. With regard to circumstantial evidence, however, you must keep in mind that the inferences you draw must be reasonable and warranted by the evidence. In a chain of circumstantial evidence, it's not required that every one of your inferences and conclusions be inevitable, but it is required that each of them be reasonable and that they all be consistent with one another, and that together they establish the defendant's guilt beyond a reasonable doubt. Now, if the Commonwealth's case is based solely on circumstantial evidence, you may find the defendant is guilty only if those circumstances are conclusive enough to leave you with a moral certainty, a clear and settled belief the defendant is guilty, and that there's no other reasonable explanation of the facts to be proven. The evidence must not only be consistent with the defendant's guilt, they must also be inconsistent with his innocence. Whether the evidence is direct or circumstantial, the Commonwealth must prove the defendant's guilt beyond a reasonable doubt. Now, as the judges of the facts, you're the sole judges of the credibility of the witnesses. You alone will determine which witnesses to believe and how much weight to give their testimony. You should give the testimony of each witness whatever degree of belief of importance you judge it is fairly entitled to receive. You may believe everything a witness says, part of it, or none of it. If you do not believe a witness's testimony that something happened, your disbelief is not evidence that it did not happen. When you disbelieve a witness, however, it does mean that you have to look elsewhere for credible evidence on that particular issue. Police officers have testified in this case, and their testimony is entitled to no greater or lesser weight simply because of their status as police officers. You're to assess their credibility just as you would any other witness. In evaluating the credibility of a witness and deciding how much importance to give it, you should consider the following issues. First, is the witness trying to tell the truth, lying, bending the truth, or exaggerating? Often it may not be what a witness says, but how he or she says it that might give you a clue whether to accept his or her version of events as believable. You may consider a witness's character, appearance, and demeanor in the witness stand, his or her frankness or lack of frankness in testifying, whether the testimony is reasonable or unreasonable, probable or improbable. You may also consider any motive the witness has to testify in a particular way, whether the witness displays any bias, whether the witness has any interest or stake in the outcome of the case. Now, simply because a witness has an interest in the outcome of the case does not mean the witness is not trying to tell the truth as he or she recalls it, but a witness's interest in the case is a factor that you may consider in determining whether the witness is indeed telling the truth. Next, or second, is the witness sincerely trying to tell the truth, but mistaken in his or her observation or memory. Here you may take into account how good an opportunity the witness had to observe the facts about which he or she has testified, the likelihood the witness accurately understood what he or she saw, the quality of the witness's memory, and the extent to which the event in question would be remembered and remembered accurately. In this regard, there was evidence that some witnesses in this case used or were addicted to drugs. And if you determined they were under the influence of drugs at the time of the events, which were the subject of their testimony, or that their drug addiction otherwise affected their ability to perceive and remember, you may consider the effect drugs may have had on their ability to observe the events about which they've testified and to recall those events accurately. Third, that the witness prior to trial make any statement or act in a way that was inconsistent with the testimony the witness gave on the witness stand. If so, you may consider whether that inconsistency was significant or not in the context of this case, and whether it reflects an intentional falsehood, an innocent difference in memory, or a correction of a past misstatement. You're not required to believe or disbelieve a witness because his or her testimony has or has not been impeached or contradicted. It's for you and you alone to decide the believability of each witness and to give the testimony of each witness such weight, if any, you believe the testimony deserves. Now, you've heard the testimony of a witness for the Commonwealth, Rochelle Bond, who has entered into an agreement with the Suffolk County District Attorney's Office. That agreement provides that, in exchange for Ms. Bond's cooperation and her truthful testimony, the Suffolk County District Attorney's Office has made certain concessions in her case, particularly with regard to the sentence that she should receive to the charges that she has pleaded guilty to. Because of this agreement, you should examine Ms. Bond's credibility with particular care. You must determine whether her testimony has been affected by any benefits that she has received or hopes to receive pursuant to that agreement. You should also consider the fact that the government does not know whether Ms. Bond is in fact telling the truth, since that is a question for you alone to decide. Now, in the course of the trial, you heard testimony from certain individuals who were allowed to express their opinion on certain matters. For example, Henry Niels, the medical examiner, was permitted to express his opinion as to the cause of Bella Bond's death. Ordinarily, a witness may testify only to things that he or she saw or heard or felt with his or her own senses. But we make an exception to this rule for those witnesses who, because of their training and experience, have attained some level of expertise in a particular field. Those persons may testify not only to facts but also to opinions and the reasons for those opinions on issues that are within the witness's field of expertise. Because a particular witness has a specialized training and experience in his or her field does not put that witness on a higher level than other witnesses. That is, such opinion testimony is subject to the same rules as that from other witnesses. You may believe all the testimony, part of it or none of it. There's no obligation for you to believe or disbelieve an opinion witness merely because he or she has testified as a so-called expert in the case. You're to assess the credibility of that witness just as you do any other witness. It's also entirely up to you to decide whether you accept the facts relied on by the expert and to decide what conclusions, if any, you draw from the expert's testimony. You're free to reject the testimony and opinion of a witness, of an expert witness, in whole or in part, if you determine that that witness's opinion was not based on either sufficient education or experience, or if you find that the testimony of the witness was motivated by some bias or interest in the case. You must also, as has been explained, as already explained, keep firmly in mind that you alone determine what the facts are. If you conclude that the expert's opinion is not based on the facts as you find those facts to be, then you may reject the testimony and opinion of the expert in whole or in part. You must remember that expert witnesses do not decide cases. Juries do. And in the last analysis, an expert witness is like any other witness in the sense that you alone make the judgment about how much credibility and weight to give that person's testimony and what conclusions you draw from that testimony. In short, it's up to you and you alone to decide what weight to give that opinion testimony. Now, you have all the exhibits that are in evidence with you in the jury room, and you should consider exhibit evidence in the same way as witness testimony. That is, you may determine whether you believe what's contained or reflected in that exhibit, and if so, what weight it deserves. Among those exhibits are photographs of Bella Bond after her body was discovered. These photographs were admitted into evidence to show the nature and extent of any injuries to her, and so that you could understand other evidence regarding the condition of her body. View these exhibits only with that purpose in mind. Your verdict must not in any way be influenced by the fact that these photographs are disturbing to look at or that they may arouse certain emotions. Mr. McCarthy is entitled to a verdict based solely on the evidence and not one that is based on pity for the victim. That concludes my instructions to you on general matters of law. So at this time, I'm going to have the court officer distribute a couple of pieces of paper, a verdict slip, and also what we call a chalk that's been prepared by our own state Supreme Court that outlines the elements of the crime, murder in the first degree, and then certain other lesser included offenses I'm going to be reviewing with you here. Is it two, I don't know if this, is it two-sided?
No.
Okay. Okay. By the way, although each of you has a verdict slip, there's only going to be one verdict slip that's actually returned here in open court, that the one which is going to be filled out by the four persons, signed and dated. You can certainly take those verdict slips back with you in the jury room as you will your notes. Okay, turning to my specific instructions, Mr. McCarthy is charged in a single indictment with the murder of Bella Bond. There is therefore a single verdict slip that you will be filling out, and because I'm going to be talking about certain parts of that verdict slip, I gave you all copies. Murder is the unlawful killing of a human being. There are two different degrees of murder, murder in the first degree and murder in the second degree. If you find the defendant guilty of murder, the jury decides, and you shall decide, the degree of murder. The Commonwealth alleges that Mr. McCarthy committed murder in the first degree on the following theories. First, murder with deliberate premeditation. Second, murder with extreme atrocity or cruelty. To find the defendant guilty on either of these theories of murder, you must be unanimous. That is, all the deliberating jurors must agree that the Commonwealth has met its burden of proving every required element of that particular theory beyond a reasonable doubt. You should check the appropriate block or blocks on the jury verdict slip as to each theory on which you agree unanimously. As I think it indicates on the verdict slip when it says and or, you can pick one or both of the theories or neither. That is, if you cannot agree, that you won't be able to choose either one. If you are unable to agree unanimously that the Commonwealth has met its burden of proving beyond a reasonable doubt either of these two theories of first-degree murder, then you shall go on to consider whether the Commonwealth has proved beyond a reasonable doubt the defendant is guilty of murder in the second degree. If you're unable to agree unanimously that the Commonwealth has proved beyond a reasonable doubt the defendant is guilty of murder in the first degree or murder in the second degree, you shall then consider whether the Commonwealth has proved beyond a reasonable doubt the defendant is guilty of the lesser included offense of involuntary manslaughter. That's why there's so many choices on this verdict slip. As with murder in the first degree, the Commonwealth is alleging two theories as to involuntary manslaughter, and you're to consider both of them. Again, you should check the appropriate block or blocks on the verdict slip as to each theory on which you agree unanimously. If you conclude that the Commonwealth has not proved either theory beyond a reasonable doubt, then you must find the defendant not guilty. You have a duty to find the defendant guilty of the most serious offense that the Commonwealth has proved beyond a reasonable doubt, which in the case of murder is murder in the first degree. If the evidence does not prove beyond a reasonable doubt that Mr. McCarthy is guilty of either murder in the first degree or murder in the second degree, or that he is guilty of the lesser offense of involuntary manslaughter, then you must find him not guilty. I'm going to begin by instructing you then on the elements of proof for each of these two theories of murder in the first degree, and that's where this chalk might come in handy because it has that outline. I will next instruct you on murder in the second degree. I will then instruct you on involuntary manslaughter. With these instructions, I have this chart that outlines the elements of each murder in the first degree, murder in the second degree, and involuntary manslaughter. That chart is a summary only, and these instructions are going to be explaining what each of those elements mean. So turning first to first-degree murder committed with premeditation. To prove the defendant guilty of murder in the first degree with deliberate premeditation, the Commonwealth must prove beyond a reasonable doubt the following elements. First, that Mr. McCarthy caused the death of Bella Bond. Second, that Mr. McCarthy intended to kill Bella. That is, that he consciously and purposefully intended to cause Bella's death. Third, that Mr. McCarthy committed the killing with deliberate premeditation. That is, he decided to kill after a period of reflection. I will now discuss each of these elements in more detail. The first element is the defendant caused the death of Bella Bond. A defendant's act is the cause of another person's death where the act in a natural and continuous sequence results in death, and without which death would not have occurred. The second element is the Commonwealth must prove is the defendant intended to kill Bella Bond. That is, that he consciously and purposely intended to cause Bella's death. The third element is the defendant committed the killing with deliberate premeditation. That is, that he decided to kill after a period of reflection. Deliberate premeditation does not require any particular length of time of reflection. A decision to kill may be formed over a period of days, hours, or even a few seconds. The key is the sequence of the thought process. First, the consideration whether to kill. Second, the decision to kill. Third, the killing arising from that decision. There's no deliberate premeditation where the action is taken so quickly the defendant takes no time to reflect on the action and then decides to do it. As I explained earlier, the Commonwealth alleges the defendant committed murder in the first degree under two theories. So I've defined for you one of those theories, murder with deliberate premeditation. I will now define the elements of murder in the first degree with extreme atrocity or cruelty. You shall consider this theory of murder in the first degree regardless whether or not you find the Commonwealth has proved murder in the first degree with deliberate premeditation. To prove the defendant guilty of murder with extreme atrocity or cruelty, the Commonwealth must prove the following elements beyond a reasonable doubt. First, that Mr. McCarthy caused the death of Bella Bond. Second, that Mr. McCarthy either intended to kill Bella or intended to cause grievous bodily harm to Bella or intended to do an act which in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. The third element the Commonwealth must prove is that the killing was committed with extreme atrocity and cruelty. I will now discuss each of those requirements in more detail. The first element is that the Commonwealth must prove the defendant caused the death of Bella Bond. As I explained earlier, a defendant's act is the cause of another's death, where the act in a natural and continuous sequence results in death, and without which death would not have occurred. The second element is the defendant must have intended to kill Bella Bond or intended to cause grievous bodily harm to her or intended to do an act which in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. Now, as you can see, this second element has three subparts, which I will call prongs, and the Commonwealth satisfies its burden of proof if it proves any one of these three prongs beyond a reasonable doubt. The first prong, the defendant intended to kill, is the same as the second element of murder in the first degree with deliberate premeditation. The second and third prongs are different from any element of murder in the first degree with deliberate premeditation. The second prong, more specifically, is the Commonwealth must show the defendant intended to cause grievous bodily harm to Bella Bond. Grievous bodily harm means severe injury to the body. The third prong is the defendant intended to do an act, which in the circumstances known to the defendant, a reasonable person would have known, created a plain and strong likelihood that death would result. So let me help you understand how to analyze that third prong. You must first determine whether Mr. McCarthy intended to perform the act that caused Bella's death. If you find he intended to perform the act, You must then determine what the defendant himself actually knew about the relevant circumstances at the time he acted. Then you must determine whether, under the circumstances known to the defendant, a reasonable person would have known that the act intended by the defendant created a plain and strong likelihood that death would result. The third element of murder with extreme atrocity and cruelty is that the Commonwealth must prove that the killing was committed with extreme atrocity or cruelty. Extreme atrocity means an act that is extremely wicked or brutal, appalling, horrifying, or utterly revolting. Extreme cruelty means the defendant caused the person's death by a method that surpasses the cruelty inherent in any taking of human life. You must determine whether the method or mode of a killing, this killing was so shocking as to amount to murder with extreme atrocity or cruelty. The inquiry focuses on the defendant's action in terms of the manner and means of inflicting death and of the resulting effects on the victim. In deciding whether the Commonwealth has proved beyond a reasonable doubt that Mr. McCarthy caused the death of Bella with extreme atrocity or cruelty, you must consider the following factors. First, whether the defendant was indifferent to or took pleasure in the suffering of Bella. 2, the consciousness and degree of suffering of Bella. 3, the extent of injuries that Bella suffered. 4, the number of blows delivered. 5, the manner, degree, and severity of the force used. 6, the nature of the weapon, instrument, or method used. And 7, the disproportion between the means needed to cause death and those employed. This seventh factor refers to whether the means used were excessive and out of proportion to what would be needed to kill a person. You cannot make a finding of extreme atrocity or cruelty unless it is based on one or more of the factors I have just listed. Now, if you're unable unanimously to conclude that the Commonwealth has proved the elements of murder in the first degree, whether under a theory of deliberate premeditation or under a theory of extreme atrocity or cruelty, then you will consider whether the Commonwealth has proved murder in the second degree. In order to prove murder in the second degree, this is on the second page of that chalk, the Commonwealth must prove the following elements. First, the defendant caused the death of Bella Bond. Second, the defendant intended to kill Bella, or intended to cause grievous bodily harm to Bella, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a strong likelihood that death would result. That second element sounds familiar. The requirements of proof for murder in the second degree, in fact, are the same as murder in the first degree with extreme atrocity or cruelty, except that there is no element that the killing had to be committed with extreme atrocity or cruelty. So as to what the Commonwealth must prove with regard to these two elements, and certainly would discuss the requirement that the defendant must have caused the death of Bella Bond, I would refer you specifically to pages 18 and 19 of my instructions, and you'll have the written instructions with you, which discuss that second element in particular, those three prongs I referred to. As to that second element, I would just remind you it has three prongs and that the Commonwealth satisfies its burden of proof if it proves any one of those three prongs. And as to the third prong, you must first determine whether Mr. McCarthy intended to perform the act that caused Bella's death, and then if you do so find, you must determine whether, under the circumstances known to the defendant, a reasonable person would have known that the act intended by him created a plain and strong likelihood that death would result. Now, if after considering all the evidence in this case you conclude unanimously as a jury that the Commonwealth has proved beyond a reasonable doubt each of the elements of second-degree murder, then you should find Mr. McCarthy guilty of second-degree murder. If, after considering all the evidence, you're not satisfied that the Commonwealth has proved beyond a reasonable doubt the elements of second-degree murder, then you will go on to consider the lesser offense of involuntary manslaughter. Involuntary manslaughter is an unlawful killing unintentionally caused by wanton and reckless conduct. It is also an unlawful killing unintentionally caused by a battery the defendant knew or should have known, created a high degree of likelihood that substantial harm would result to another. In this case, the Commonwealth relies on both of those theories. Thus, like murder in the first degree, you're to consider each of them. You may find the defendant guilty of involuntary manslaughter only if you unanimously agree that the Commonwealth has proved, beyond a reasonable doubt, each and every element of one theory or both theories. That is, all the deliberating jurors must agree that the Commonwealth has met its burden of proving every required element of that particular theory beyond a reasonable doubt. If you conclude unanimously as a jury that the Commonwealth has not proved either theory beyond a reasonable doubt, then you must find the defendant, Mr. McCarthy, not guilty. I will now define precisely what it is the Commonwealth has to prove with respect to each theory. First, involuntary manslaughter caused by wanton and reckless conduct. Wanton and reckless conduct is intentional conduct that created a high degree of likelihood that substantial harm will result to another person. Wanton and reckless conduct usually involves an affirmative act. To prove the defendant is guilty of involuntary manslaughter because of wanton and reckless conduct in this case, the Commonwealth must prove the following elements beyond a reasonable doubt. First, that Mr. McCarthy caused Bella Bond's death. Second, that he intended the conduct that caused her death. And third, that his conduct was wanton and reckless. I've already defined for you the first element. The second element is the defendant, the Commonwealth must prove the defendant intended the conduct that caused Bella's death. On a charge of involuntary manslaughter, the Commonwealth is not required to prove the defendant intended to kill Bella. It is sufficient if the Commonwealth proves the defendant intended the conduct that caused her death. The third element is the defendant's conduct was wanton and reckless. Wanton and reckless conduct is conduct that creates a high degree of likelihood that substantial harm will result to another. It is conduct involving a grave risk of harm to another that a person undertakes with indifference to or disregard of the consequences of such conduct. Whether conduct is wanton and reckless depends either on what the defendant knew or how a reasonable person would have acted knowing what the defendant knew. If Mr. McCarthy realized the grave risk created by his conduct, his subsequent acts amount to wanton and reckless conduct, whether or not a reasonable person would have realized the risk of grave danger. Even if the defendant himself did not realize the grave risk of harm to another, the act would constitute wanton and reckless conduct if a reasonable person, knowing what the defendant knew, would have realized the act posed a risk of grave danger to another. It is not enough for the Commonwealth to prove the defendant acted negligently, that is, in a manner that a reasonably careful person would not have acted. The Commonwealth must prove the defendant's actions went beyond negligence and amounted to wanton and reckless conduct, as I've defined that term. The second theory, involuntary manslaughter unintentionally caused by a battery. Involuntary manslaughter is also an unlawful killing unintentionally caused by a battery that the defendant knew or should have known endangered human life. To prove that Mr. McCarthy is guilty of involuntary manslaughter under this theory, the Commonwealth must prove beyond a reasonable doubt the following elements. First, the defendant caused Bella Bond's death. Second, the defendant intentionally committed a battery upon Bella that endangered human life. Third, the defendant knew or reasonably should have known that the battery endangered human life. So I've already discussed the first element a few times. The second element is the defendant intentionally committed a battery on Bella that endangered human life. A battery is the intentional and unjustified use of force upon the person of another. To satisfy this element, the Commonwealth must prove that the battery created a high degree of likelihood that substantial harm would result to Bella. Because the essence of manslaughter is an unintentional killing, the Commonwealth need not prove the defendant intended the death that resulted from the battery. The third element is the defendant knew or reasonably should have known that the battery endangered human life and that it created a high degree of likelihood that substantial harm would result to Bella. In determining whether Mr. McCarthy reasonably should have known that the battery created a high degree of likelihood that substantial harm would result, you must consider to another, that is Bella, you must consider the nature and the extent of the defendant's knowledge at the time he acted, and whether in its circumstances known to the defendant, a reasonable person would have recognized that the battery created a high degree of likelihood that substantial harm would result to another. Here, Bella Bond. Now, I've defined for you precisely what the Commonwealth must prove then as to first-degree murder, second-degree murder, and involuntary manslaughter. Note that I said nothing about motive. That is because the Commonwealth does not have to prove the defendant had any particular motive for the killing. You may consider any evidence you've heard relative to a particular motive for the killing in considering whether the Commonwealth has proved the defendant's guilt. However, motive is not one of the elements the Commonwealth must prove for you to find Mr. McCarthy guilty of murder or manslaughter. Although the Commonwealth need not prove motive, you may not return a verdict of guilty as to any crime listed on this verdict slip if you have a reasonable doubt as to whether Bella's death was accidental. Similarly, you must find Mr. McCarthy not guilty if you have a reasonable doubt as to whether Bella's death was caused by a negligent, careless, or mistaken act of the defendant, or resulted from a cause separate from the defendant's conduct. The evidence presented in this case, coupled with the arguments that counsel just made to you regarding that evidence, raise three additional matters about which I instruct you as follows. First, there's been questions raised by the defendant as to whether the police failed to undertake certain steps before making a decision to charge Mr. McCarthy with murder. It's entirely up to you to determine if there were, in fact, any omissions in the police investigation. If you determine that there were, then you must decide whether those omissions are significant or not in the context of this case. And in making that determination, you should ask yourself the following questions. Was the action which was not undertaken standard procedure or of the type that police normally would have performed or undertaken under the circumstances? Second, if the action had been taken, could it reasonably have been expected to lead to significant evidence of the defendant's guilt or innocence? Third, was there evidence which provides a reasonable and adequate explanation for the omission of this action? If you find that any omission in the investigation was significant based on your analysis of these factors, then you may consider the extent to which those omissions tend to affect the quality, reliability, or credibility of the evidence presented by the Commonwealth. All these considerations involve fact determinations that are entirely up to you to decide. Second, the Commonwealth has presented evidence that the defendant engaged in certain conduct which suggests are indicative of feelings of guilt on the part of Mr. McCarthy. If you credit that evidence and you find that the Commonwealth has proved beyond a reasonable doubt that Mr. McCarthy engaged in the conduct cited by the Commonwealth, then you are permitted to consider whether such conduct does in fact indicate feelings of guilt by Mr. McCarthy, and in turn, whether such feelings of guilt might tend to show his actual guilt on the charge before you. A few cautions, however. You're not required to draw any inference of guilt from the conduct of the defendant, which you find that you're not required to draw any inference of guilt from the conduct of the defendant, which you find that the Commonwealth has proved. That is, you're permitted to draw an inference, you're not required to draw this inference. Moreover, you should not draw such an inference unless it appears to be a reasonable one in light of all the circumstances in this case. If you decide that such inferences are reasonable, it will be up to you to decide how much importance to give them. Bear in mind that a person having feelings of guilt is not necessarily guilty in fact, for such feelings of guilt are sometimes found in innocent persons. Finally, I caution you that standing alone, this evidence is never enough by itself to convict a person of a crime. You may simply consider such conduct together with other evidence in the case to determine whether the Commonwealth has satisfied its burden of proof. Third, Mr. Shapiro stated, I think at the beginning of his closing argument, that you can find Mr. McCarthy guilty only if you conclude that Mr. McCarthy and Mr. McCarthy alone killed Bella. As to that, I would simply instruct you as follows. The Commonwealth bears the burden of proving beyond a reasonable doubt that Mr. McCarthy killed Bella. On the other hand, the Commonwealth does not have the burden of excluding the possibility that one or more other persons were also involved in the crime. Mr. McCarthy is the individual on trial here. You must determine whether, as to Mr. McCarthy, the Commonwealth has proved each and every element of the crime, whether that is murder as I defined it for you, or of the lesser included offense of involuntary manslaughter. If you conclude, and again that's proof, the burden there is proof beyond a reasonable doubt. If you conclude that the Commonwealth has sustained its burden, then you should find the defendant guilty. If it has not sustained its burden, then you must find Mr. McCarthy not guilty. Let me talk to the lawyers, and we're at a few housekeeping matters. I'll return shortly. We're almost done. Lunch awaits. So let me now say a few words about your deliberations. When you retire to the jury room to begin your deliberations, each of you should consider all the evidence, listen to the views of your fellow jurors, and discuss the case with them in an effort to reach agreement regarding a true and just verdict. Although I leave it to you to decide how you wish to deliberate, I would urge you not to take an immediate straw vote to determine where each of you stands. Rather, I would encourage you to first review and analyze all the evidence before anybody is asked to express his or her views regarding a verdict. It is important that you reach a verdict if you can do so in good conscience. That means you should listen carefully and respectfully to your fellow jurors. The collective memory and insight of the other 11 jurors can assist each of you in finding the facts and arriving at a true and just decision. You should not hesitate to re-examine your own views and change them if you're persuaded that you were wrong. At the same time, each of you must decide this case for yourselves. So you should not surrender, nor am I asking you to surrender your honestly held conclusions simply to arrive at a verdict. I have permitted you to take notes during the trial, in part because there's no transcript available of these proceedings which can be given to you. You can refer to those notes for your own purposes during the deliberations, but as I cautioned you at the beginning, please do not read them or give them to other jurors in an effort to convince them that your memory is better. In fact, it may be that the memory of a juror who did not take notes is better. Ultimately, it is this collective memory of all 12 of you that controls. You should not commence your deliberations until all 12 are together in the jury room, and you should cease deliberating if any one of you is not present. In that regard, you know that if you're a smoker, you have to leave the building to smoke, and I will leave it to the foreperson to determine whether and when there will be a smoking break. By the way, you have to go in the company of the court officer since we're in the middle of deliberations. If there are smoking breaks, remember that deliberations must cease until the smokers return. Also, I presume all of you have cell phones or other electronic devices by which you communicate with the outside world. I would just ask that you turn those devices off in the deliberations room. If you have to be on some kind of emergency standby and must use a cell phone, I would ask that you step outside the room and use it in the company of a court officer, keeping in mind that the prohibition against talking about this case with anyone besides your fellow jurors remains in effect. It's important that you not communicate with anyone outside the jury room about your deliberations or about anything else concerning this case. That includes the court officers. They're there to assist you with lunch and the like. You're not to indicate to them at any time what you're talking about or where you stand in your deliberations, numerically or otherwise. If it becomes necessary during your deliberations to communicate with me, you may do so by sending a note through the court officer signed by the juror designated as foreperson, identifying the time of the note. I will then consult with the attorneys regarding the appropriate response and communicate that response to you. No member of the jury should ever attempt to communicate with the court except through a signed note. If you do send me a note, do not disclose to me anything about the contents of your deliberation. Specifically, do not disclose to me how anyone in the jury stands numerically or otherwise until you've actually reached a unanimous decision. Now, I've mentioned a couple times that 12 of you are deliberating, and we know that there's 14 of you there. So unfortunately, it means we have to reduce your number to 12. It's my least favorite part of the case because all of you have been paying careful attention, but the law says that only 12 people can deliberate in a criminal case. We always pick more than we need in case something happens to one of the deliberating jurors, and that does happen occasionally. That alternate, the person designated as an alternate, is then used to substitute for the absent deliberating jurors, so we don't have to try this case all over again. But the fact remains that only 12 of you can deliberate. So we're going to reduce the number, and we're going to do that by picking your numbers out of a barrel there, much like the lottery. It means two things. If you're designated an alternate, you cannot not only participate in deliberations, you cannot even be in the room to listen to what's said. You have to be kept in a separate place. Second, you cannot leave. Your presence may still be required. So if fate makes you the alternate, please don't take it personally. You may still be needed on the jury, and you're still performing a very important service. So the clerk will now reduce the jury to 12.
The time has come for the final submission of the case to the jury. And there being present a panel of 14 jurors, the Court Judge Sanders has just ordered me to reduce the jurors to 12 members. I have the seat numbers of all jurors in the barrel. I will draw the seat numbers of 2 jurors who will be designated as alternate jurors to be kept separate and apart from the rest of the jury and in custody of the court officers until further order of the court. Juror in seat number 10, Lindsay Young. And juror in seat number 15, Olga Provost. You've been designated as alternate jurors.
You will be getting lunch, though. I had mentioned a 4-person, and you may wonder who that's going to be. Rather than doing it in the very random way we just did it, or have me select a 4-person, which I regard as almost equally as random, since I've adopted the practice of having you select your own person, 4-person, on the idea that you know each other better than I do. So that'll be your first select a 4-person. Don't take too much time on this. It can be majority vote, volunteer. If you have any difficulties, let me know, and I will appoint a 4-person. I would just suggest, however, that you pick somebody that's good at running a meeting, because that's basically what a 4-person does. Make sure everybody has a chance to express his or her views. The 4-person's vote does not count any more or less than any other person's vote. The 4-person does have the responsibility of writing out a note if any one of your number has a question, and the 4-person would be the person to actually fill out the verdict slip, sign it, and date it once you've unanimously agreed as your decision. And then the 4-person would respond to certain questions here in open court when the verdict is returned. So that'll be your first order of business, to select a 4-person. So with that, I will swear in the court officers who will escort you to your deliberations.
Raise your right hand. Each yourself is free to take charge of security. Keep them together as a convenient way. Keep them yourself and suffer anyone else to speak to them, except by order of the court, or to ask them if they are agreed to help you God.
You will now retire to consider your verdict.
Court, all right, please. Jury, please take notes.